Hello! In the following, I would like to give you an overview of what happens during the international search procedure and what tasks the international searching authorities are performing. So first of all, what is an international searching authority, or an ISA, how we often refer to them? What main duties do they perform, and how will they actually perform an international search? And at the end, I would also like to touch upon the various reports which are issued by the International Searching Authority. So what is an International Searching Authority? Well, an ISA essentially is a patent office of one of the contracting states of the PCT that has volunteered to act as international searching authorities for international applications filed. So how do you become an ISA? Well, you first have to show that you comply with a minimum quality standard, and that standard is defined in terms of that you have access to sufficient documents that you can search, but also that you have sufficient staff and manpower to perform those searches. And as a last important step, you need to be appointed by the PCT Assembly as an international searching authority. Currently, we have more than 10 active international searching authorities, and those are, on the one side, the big, large patent offices of the world, the European Patent Office, the USPTO, the JPO, the Japan Patent Office, but we also have smaller mid-sized offices that currently work as international authorities under the PCT. So what are the main tasks of the International Searching Authority? One of the first things an ISA will do when they receive the search copy from the receiving office, they will check whether there's one invention in this particular application or whether there are multiple inventions. This is called looking for whether there is unity of invention in that particular application. If they find that there is lack of unity, which means there's more than one invention in a particular application, then they would ask the applicant to pay additional search fees. A second step of what they are performing would be that they are checking the title and the abstract of the international application. They will check whether they are in compliance with the PCT requirements, whether they are concise and they are meaningful in terms of describing what the actual application is all about. If they think it does not comply with the regulations, they will redraft either or both the title and the abstract of the particular international application. They're also in charge of authorizing the rectification of obvious mistakes if that mistake is somewhere in the claims, in the description, or the drawings of the international application. And the applicant would have to address the ISA with such a request, and they will eventually decide, yes, this is an obvious mistake, we can authorize it, and then this would be communicated to the International Bureau, and we could then take it for publication purposes so that the IB would publish the rectified version of the international application. Of course, the main task of the International Searching Authority is to search the claimed invention, and I'll come back to that in more detail. And at the end of the search, they will establish a search report, an international search report, and a written opinion of the ISA. So how will an international search actually be conducted? Well, the purpose of the international search, just like a national search, is really to look for any relevant prior art that is already out there. And the ISA does that by going through at least a stock of minimum documents which they're obliged to search. So here we're talking about patent documents, but also about technical journals, so-called non-patent literature. They will go through all this and try to identify documents which are particularly relevant for the claimed invention. Now, most ISAs have actually more documents available to them than what is covered by the PCT minimum documentation. And of course, in that case, they will go through all of the documents. And today, this is mostly done by simply going through electronic databases where they search for those relevant documents. Now, once the identified certain relevant documents for the particular application, they will cite these documents in the search report. But they don't only cite the documents as such, but they will also give an indication for which particular claim that document is relevant and in which manner the document is relevant. So for instance, if they find a document that on its own would really already disclose the same invention that the applicant is claiming in his application, they would call it an X document and they will mark it as such in the search report. Sometimes they only find a document which together with another document could be taken as already describing what the applicant is now claiming in so much detail that anyone skilled in the art, if he takes those two documents together, he would immediately come up with the same invention. And that would be something where the examiner would then say, because of these two documents, it's already obvious and it's not inventive, and he would give it a Y citation in the search report. Now, it is also clear that in order to do an international search and to look for relevant prior art, you actually need a precise definition of what prior art is. And the PCT does contain such a definition. And the way the PCT defines prior art for the purposes of international search is that prior art is everything which has been made available to the public anywhere in the world by means of written disclosure. So excluding mere oral disclosure, it has to be written disclosure, but written disclosure could also be a drawing. It doesn't have to be written text. And of course it has to be capable in assisting the examiner in determining whether the claimed invention is or is not novel, is or is not inventive. Another important feature of the definition is that prior art for us is only anything which has been made available prior to the international filing date. Now that might be a bit surprising. You might think, why the international filing date? Shouldn't it be the priority date? Because if someone claims priority, shouldn't he be protected against prior art in between the filing of the first application of which he claims priority and the PCT? And you're right, in principle he would be protected. But the founding fathers and mothers of the PCT thought at the time that it might be better to search everything up until the international filing date, because at that point in time, we're not really sure yet whether the priority claim will really hold. The priority document in most instances hasn't really been furnished to the International Searching Authority, is not available to the International Searching Authority, and therefore they cannot check it. And so no one really has checked the validity of the priority claim. And as a result, it was felt it's better, just because it could happen that the priority claim will not be kept in the application eventually, that the search should be done up until the international filing date. What's the time limit to establish this search report? And by the way, it's the same time limit also to establish the written opinion of the ISA, and I'll come back to that second report in a moment. Now, the time limit to establish the search report and written opinion is, in principle, approximately 16 months from the priority date. The treaty and the regulations actually do not mention 16 months anywhere, but we assume that most applicants file at the end of the priority period. Then it takes the receiving office about a month to send the search copy to the International Searching Authority, and then under the treaty it is said that they need to establish the search report within 3 months from the date of receipt of the search copy. So 13 months plus 3 takes us to the 16 month, and that's why we usually say search report should more or less be established at around 16 months from the priority date. There's actually another time limit in the PCT, which is 9 months from the priority date, but this really only applies in cases where an applicant does not have a priority claim in his international application or files very early on in the priority period. So in this case, if the 9 months expire after the 3 months from date of receipt of the search copy, it would be the 9 months which are applicable, but again, this is more in exceptional cases. There are sometimes cases where no search report is established. And in this case, the ISA would issue what is called an Article 17 declaration. This could, for instance, happen in a case where an ISA has told us that they will not conduct a search in a particular technical area. An example for this would be, for instance, business methods. ISAs do not have to search business methods if they tell us about this in advance. And for instance, the EPO has informed us they will not do a search concerning business methods. So if the application concerns a business method, the EPO would declare in this case that no search can be done, and they would issue what we call an Article 17 declaration. I already mentioned the written opinion of the ISA. So what is it? Well, the written opinion is a preliminary, non-binding opinion on the three main criteria of patentability: novelty, inventiveness, and industrial applicability. The latter is also sometimes referred to as usefulness. So, in a way, what the written opinion covers is very similar to what the search report also looks at, but it gives the reader a bit more of a detailed explanation as to why the examiner thinks that certain claims are novel or not novel, are inventive or are not inventive. So it's a little more accessible also to those who do not maybe study search reports every day in much detail. So for the layperson, it's a more accessible report. The written opinion is established at the same time as the international search report and will be communicated to the applicant. Of course, the IB, the International Bureau, also gets a copy, but we will not publish the written opinion. So the search report, I mentioned this earlier, is published together with the international application, but the written opinion at that point in time is not published. There's also no formal procedure for the applicant to rebut the findings in the written opinion. But there is an informal procedure referred to as informal comments, which the applicant is entitled, if he wishes to do so, to submit such informal comments to the International Bureau, and we will then communicate them on to the designated offices. There's another report I would like to mention, and that is the IPRP Chapter 1. That stands for International Preliminary Report on Patentability under Chapter 1 of the PCT procedure. So this is a report which is established if no demand for international preliminary examination is subsequently filed by the applicant. The IB is actually in charge of establishing this report. But what the IB does is we simply use the written opinion of the ISA. We put a new cover sheet on top of it, and on that cover sheet it reads IPRP Chapter 1. This is the report that we would communicate to the designated offices together if they have been submitted with any informal comments by the applicants. This will only happen at 30 months, and at that time both the IPRP, the written opinion, and possibly any informal comments would also be available to the general public on Patent Scope. They are published or made available to the public as related documents in the file of an international application. Now, what happens if the applicant does file a demand under the Chapter 2 procedure, so a demand for international preliminary examination? In this case, the written opinion of the ISA will automatically serve as the written opinion of the IPA. So this means the IPA does not really have to issue a written opinion at all. They can right away issue their final report, which is called the IPRP Chapter 2. That's International Preliminary Report on Patentability. There are some exceptions. First of all, an IPA is always free to issue a written opinion if they wish to do so. And some IPAs have also told us if the written opinion was established by a different authority, not by themselves, in these cases they will always establish a written opinion also of the IPA. Do note that the informal comments that an applicant might have submitted before filing a demand will not be communicated to the IPA, the International Preliminary Examining Authority. And also, if the final report of the IPA, the IPRP Chapter 2, is established, we will not send the informal comments to the elected offices. So I hope this gave you a short overview over the task performed by the International Searching Authority. I tried to explain to you how the search is actually conducted during the international phase of the PCT, and I touched upon the various reports which are issued by the International Searching Authority.